I'd like to call the meeting to order. Pursuant to the order of reference received by the committee on March 21st, 2016, the committee will now proceed to the consideration of Bill C-6, an act to amend the Citizenship Act and to make consequential amendments to another act. We have three witnesses before us. The witnesses will make opening remarks in the order which they appeared on the notice. The first witness is Mr. Shimon Fogel, Chief Executive Officer of the Center for Israel and Jewish Affairs. The second witness will be Ms. Elke Winter, Associate Professor of Sociology, Department of Sociology and Anthropology, University of Ottawa, as an individual. The third witness will be Mr. Peter Edelman, lawyer, Edelman and Company Law Offices, and he's here as an individual as well. Mr. Fogel, 7 minutes, please.
Thank you. I'm grateful to be here representing the Center for Israel and Jewish Affairs, the advocacy agent of the Jewish Federations of Canada, to discuss Bill C-6. As I noted in my testimony before this committee regarding Bill C-24, Canadian citizenship is one of the most valuable and highly respected commodities in the world, but is far from being just a prestigious status one acquires. Citizenship in this country is an unparalleled package of balanced rights and responsibilities based on a set of core values designed to ensure dignity, freedom, and equality for all. I'm certain that everyone around this table agrees that immigrants are among the proudest patriots and shapers of this country, a source of cultural vitality and economic strength. Despite the dark era of Canada's none is too many immigration and refugee policy for Jews, we've come here from all corners of the globe for more than 200 years. Our community has made a positive contribution to the Canadian story, like so many others whom we join in appreciating the extraordinary opportunity and privilege of being Canadian. We're glad that C-6 will once again allow time spent in Canada as a temporary resident to count towards the residency requirement for citizenship. This will be particularly beneficial with regard to retaining talented international students who come to this country to advance their education and skills while simultaneously integrating with Canadian peers. These would seem to be ideal candidates for citizenship, and there should be no unnecessary obstacles in their path. As this committee considers the merits of repealing many of C-24's other provisions, I'd like to highlight some elements that C-6 quite correctly will leave in place, and the importance of which cannot be overstated. Retaining a physical presence standard in determining residency requirements for citizenship is an important principle that can enhance integration and decrease marginalization of new immigrants, and as Minister McCallum has mentioned, can also help to counteract the problem of citizens of convenience. C-6 will also maintain basic language and knowledge testing requirements for citizenship applications. Coupled with physical presence, this can make a significant contribution towards counteracting the importation of anti-Semitic and other extremist views that, though marginalized here in Canada, are unfortunately still prevalent in many parts of the world. We are very pleased that C-6 does not seek to repeal C-24's streamlined provisions for revoking citizenship from those who obtained it through fraud or misrepresentation. These provisions consolidated a process that has been routinely abused by those who hid their Nazi past when coming to Canada. The ongoing case of Helmut Oberlander is a timely example. Oberlander was a decorated member of a savage Nazi mobile killing unit responsible for the murder of more than 90,000 Jewish men, women, and children. When he applied for entry to Canada in 1954, he misrepresented his wartime past and fraudulently obtained Canadian citizenship. Oberlander has avoided the final revocation of his citizenship and removal from Canada by exploiting a flawed system for more than 20 years. This ongoing experience demonstrates the need for C-24's revocation provisions to be retained, and the government's commitment in this regard should be universally supported. In this regard, I'd like to take this opportunity to thank the government for seeking leave to appeal the latest Federal Court of Appeals decision regarding the revocation of Oberlander's citizenship to the Supreme Court. There are other components that C6 seeks to repeal that we believe merit further consideration. We supported the introduction of measures to ensure that those who apply for Canadian citizenship actually intend to maintain a meaningful connection to Canada. The intent to reside provisions that C6 will repeal are an important element in this regard and could continue to have an impact on reducing the problem of citizens of convenience. However, that said, the current articulation of this provision does indeed create a potential for abuse. Safeguards are needed to preclude a minister from commencing a revocation proceeding for someone who declared intent to reside, but then went abroad to study, to work, or to tend to an ill relative. People should not fear being penalized for such eminently reasonable actions, even if the chances of a minister actually doing it are remote. In reference to this provision, Minister McCallum, when he was a member of this committee in the previous Parliament, noted with regard to, quote, the question of citizens of convenience. We want measures in place to deter that. I sympathize with that goal in principle. End of quote. Instead of repealing intent to reside, the existing law could be amended to more closely align this provision's substance with its principle. This could be achieved with a check on ministerial discretion, a requirement for the minister to seek a court declaration in cases of misrepresentation of intent to reside, similar to the requirement included for other cases of fraud. When I last appeared before this committee to testify regarding Bill C-24, I articulated a position in support of the revocation of citizenship from dual national Canadians who commit certain offences, including terrorism offences. This position was a reflection of our belief that in the case of certain particularly heinous political crimes, the perpetrator is actually guilty of two distinct offences. First, they're guilty of the particular crime they have committed. But second, they're guilty of a fundamental betrayal of the core values on which Canadian citizenship is based. Our support for this provision reflects a desire to address not just the crime, but also the grievous insult to Canada and Canadian identity that has taken place. This is why we advocated for the revocation provisions to be expanded to include those convicted of war crimes, crimes against humanity, and genocide.
Mr. Fogel, 20 seconds, please.
Okay, just actually one more paragraph. The government's articulated a different position on this issue. We respect the mandate they've received to do so and acknowledge the compelling arguments that have been made for why the law should not distinguish between dual nationals and other Canadians. But I do encourage, Mr. Chairman, members to reflect on that second dimension, the insult to Canada, and consider ways in which they can reflect that in their approach to individuals who fit these circumstances. Thank you.
Thank you, Mr. Fogel. I'd now like to call upon Ms. Winter. 7 minutes, please.
Okay. Thank you. It is a great honor to be in this House again, so thank you very much for giving me the opportunity to speak to you about Bill C-6. I am a sociologist who looks at citizenship legislation as a part of a government's effort of nation building, so more long time. My testimony here is based on past and ongoing research, and today I would like to emphasize 3 points. First, I commend the Minister for proposing to repeal Section 10(2) of the Citizenship Act, which provides the grounds for revoking citizenship related to national security. 3 points I would like to make to support this. From a nation-building point of view, the revocation of citizenship is not a solution for a social problem, because it basically means exporting potential criminals to countries that cannot handle these individuals any better than Canada. Hence, perpetrators may either be submitted to death penalty or incarcerated in inhumane conditions, or most likely the countries they're exported to may not be able to prevent them from committing terrorist acts from abroad. Neither is desirable, I believe, from a Canadian point of view. Second, research suggests that perpetrators seldom refrain from heinous crimes due to drastic penalties. Not even the death penalty deters them. Thus, potential terrorists rarely feel discouraged by the threat of citizenship revocation. Third, and probably most importantly, our research has shown that the past legislation, maybe unintendedly, contributed to the stereotyping of Canadian Muslims. Supported by a grant from Public Safety, researchers at the University of Ottawa have studied the media and social media coverage of the citizenship revocation for Canadian dual nationals convicted of, or being threatened of convicted of treason, espionage, and terrorism. You will be interested to hear that the revocation measure was actually discussed very skeptically by the media. But although the media was skeptic of that, their way of reporting also supported the idea that it is among Canadian Muslims, as well as dual Canadians more generally, that we are most likely to find terrorists. This, I would argue, is not conducive for multicultural nation building. I now come to my second kind of substantial, larger point. In my reading of Bill C6 as it's proposed, this legislation will bring Canadian law back in line with the idea that naturalization, becoming a citizen, is not an endpoint or reward of integration, but rather an important step towards immigrant integration. Comparative research shows that this approach is much more conducive to making immigrants not only part of the country's socio-economic fabric, but also to winning their hearts and minds, which is the ultimate goal when building a nation. Once again, let me make 3 points to support this. Language skills are important to facilitate participation in society, but so is formal citizenship. Restoring the previous age limits for language and knowledge testing and adjusting the language level in the application kit will reduce barriers to the less educated, the non-European language speakers, and the economically vulnerable. As we very well know at universities, testing is a stressful undertaking, specifically for older persons and accompanying family members, often women. As the previous speaker has already noticed, restoring the pre-permanent resident 50% credit towards citizenship is an important incentive to those with Canadian experience, students, refugees, former temporary workers. It highlights the interpretation of formal citizenship as a step within the longer journey to becoming fully integrated. Third, changing the residence requirement to 3 out of 5 years, I believe, is conducive to retaining immigrants who are very highly skilled, highly mobile, the so-called best brains in the world that Canada and other countries want to attract. This measure enables these individuals to also become citizens, even though they may have to work outside of the country for some time, so not be physical travel. It gives them more flexibility. Third, my third larger point. While not part of C6 as is presently proposed, I urge the government to consider implementing a recommendation made by the Truth and Reconciliation Commission, namely to revise the citizenship oath to include the respect of treaties between the Crown and Indigenous peoples. Interviews that I conducted with new Canadian citizens show that for them the citizenship ceremony and the oath are very important and meaningful elements of the naturalization process. Since the current government has already pledged to value the Truth and Reconciliation Commission's recommendations from the perspective of building a nation, this may be a good moment to strengthen the relations between our new Canadians and our oldest ones. In sum, Canada has a long history of selecting immigrants who make an economic contribution to this country. For this, it is envied in the world. This rationale, however, needs to be complemented by a warm welcome of new Canadians. And I believe that this bill, as it stands, will move the legislation closer to that end. Thank you.
Thank you, Ms. Winter. Mr. Edelman, 7 minutes, please. Thank you.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I'd like to thank you for giving me the opportunity to speak to you today. I've had the opportunity to speak with some of your colleagues in the Senate at the time that C-24 was passed. At the time, I expressed serious reservations with the bill, which was presented then, and which was adopted by Parliament last year. I'm pleased to see a lot of the changes being presented today in the bill currently before you. I was born in Canada, but I was born of immigrant parents from Switzerland. I have the right to Swiss citizenship, as do my 2 sons. And we all have dual nationality. Like many Canadians, we have access to this second nationality. According to C-24 and the current law, as it exists today, we are at risk of something other Canadians are not at risk of, and that is unfair. And Senator Eaton said, when I was before the committee, well, Mr. Edelman, all you have to do is not commit a crime, not commit a terrorist act in order not to lose your citizenship. But that's not the issue. The issue is not whether I want to commit an act of terrorism. Somebody who commits a crime will give up his citizenship in order to keep his Canadian citizenship. But that's not a solution. So I'm very happy to see the changes presented in today's bill.
More detail today is with respect to some of the reservations or some of the things that I think would be helpful to see the bill go a little bit further, or to make some changes to going either back to the system that we had, or some other changes that have been suggested by other witnesses before this committee. And I'm going to focus my comments on revocation. It's important to understand that in a world of nation states, and as long as we live in a world of nation states, citizenship is one of the most fundamental of statuses. It's the status upon which your ability to sit in this committee is predicated. It's the status upon which the ability to choose the people who sit around this table is predicated. It is the right to have rights. It's the right to have full rights as a participating member of Canadian society. It's a fundamental status, and it's deeply important to the people who hold it. And many, many Canadians, and many of your colleagues, are naturalized citizens. And for naturalized citizens to lose that status is one of the most fundamental losses that they can have. And under the current law, we have more procedural fairness built into our law around parking fines and traffic tickets than we do around loss of citizenship. The revocation of citizenship under the current law happens with a decision by a single officer. So what happens is that you get a letter in the mail that says, please tell us why we shouldn't take away your citizenship. And then you send submissions to the officer, and the officer can decide whether or not they want to hold an interview. They may interview you, they may not. You may just get a letter in the mail saying, you're no longer a citizen. Now, at that point, you are no longer a citizen. You can go to federal court, and you can ask for permission from the federal court for them to hear your case, to judicially review that decision from the officer. But you're doing that from the position of a non-citizen. At that point, you are often may well be in the removal stream at that point, and I'll talk about the situation of permanent residence at that point. But that is a very, very fast and a process with very few procedural safeguards and very little transparency. Prior to C-24, the process was very different. You would get the notice in the mail. You would have the opportunity to convince the minister as to why they should or should not seek the revocation of your citizenship. You could then ask to go to the federal court. The federal court would decide whether or not the misrepresentation or the fraud upon which you obtained your citizenship was in fact serious enough to warrant the loss of citizenship. And then the governor in council would ultimately decide whether to revoke the citizenship. Now, there have been examples of cases that have taken a long time. The reasons for those delays in the Oberlander case or other cases there are a number of reasons why there may have been some delays, but the process itself does not require those types of delays. We have procedural safeguards for the loss of permanent residence that are much more rigorous. A permanent resident who's going to lose their status, in the vast majority of cases, will get a notice and an opportunity to make submissions. They then get a hearing before the Immigration Appeal Division, where they can present not only an argument as to why they shouldn't lose their status, but also will get an opportunity to present humanitarian and compassionate or compelling reasons why, despite the misrepresentation, they shouldn't lose their status. Not all misrepresentations are equal. Some are very, very serious. Others are relatively trivial. And the question is whether a single officer should be making a decision as fundamental as the one that we're talking about. Now, in the law as it currently stands, there's a particular problem with respect to persons who are found to have misrepresented when they got their permanent residence. Because before you get your citizenship, if you are found to have misrepresented when you got your permanent residence, you get access to the Immigration Appeal Division. You get access to an opportunity to present humanitarian and compassionate factors, to say, well, despite the fact that I misrepresented 20 years ago, I now have children and a family here. Once you become a citizen...
20 seconds, please.
Thank you. Once you become a citizen, under the law as it currently stands, you go straight back to being a foreign national if you are found to have misrepresented when you got your permanent residence. You don't go back to being a permanent resident. You go straight back to being a foreign national. Therefore, your status is more precarious once you've become a citizen than it was when you were still a permanent resident. So I would urge this committee to make some amendments with respect to those two aspects, and I thank you for your time.
Thank you, Mr. Edelman. We now move to the first round of questions to our witnesses. Ms. Zaid, 7 minutes.
Thank you, Chair, and I'd like to take this opportunity to thank all our witnesses for providing their valuable input. My first question is for Ms. Winter. Ms. Winter, in your testimony before this committee on Bill C-24, you referenced research you were conducting regarding the raising of suspicion against dual nationals and their detrimental impact that legislation such as C-24 and others has had on some communities, particularly Muslim and Arab Canadians. You mentioned numerous rants against Muslims in print media, online fora, and social media, with negative stereotypes being extended and amplified by Bill C-24. As a Muslim Canadian, I have seen these stereotypes firsthand. Could you update us on this research and any conclusions your team has reached?
Okay, that works for itself. Thank you. Yes, actually, I reviewed that statement, and we've just completed the story, so I can. What we did is we looked at the task that we were given by public safety to see to what extent the government policy would lead to the stereotyping of Muslims. So what we kind of looked at, we looked at the law, how it looked at, is written. We looked at your discussions in Parliament and in the House of Commons. We then looked at the mainstream media, newspapers, and my students tell me, look at social media. So what you can actually see is, while the law obviously applies in the same way to everyone alike, the discussions in the House of Commons and in the Parliaments were fairly balanced. You can see much more of those stereotypes coming out in the newspapers and even more in the social media. However, and in this one I have to kind of credit the Canadian media, which is not often the case that I would do it. They were very concerned about the fact that this law would target Muslims. So they spoke critically about this, and for the most part, however, as I said, at the same time, by always assuming that this law was something that was there because there are Muslims, and while not all of them would be terrorists, it would be them among most likely would find terrorists. So in that sense, they contributed to the stereotyping of a vulnerable group. And I think what it shows is that a law that may not intentionally target a particular group may ultimately lead to this, because once the ghost is let out of the bottle of revocation as a legitimate means to penalize someone and to punish someone, it is very difficult to be contained.
Thank you, Ms. Winter. My next question is for Mr. Fogel. I'm confused by your support of the intent to reside provision of Bill C-24 that is being proposed to be repealed in Bill C-6. I think we all dislike the concept of the so-called citizens of convenience. As you know, the Charter of Rights grants all Canadians mobility rights. That's per the Charter of Rights. So the intent to reside provision would seem to be unenforceable symbolism. How do you reconcile with this thing with the Charter?
None of the issues that are being raised, I think, are very simple or lend themselves to easy kind of solutions. And I think that what you're implying is correct insofar as we do want to balance between benefiting from a degree of confidence that those that express an interest in securing Canadian citizenship have the intent of participating fully in the Canadian experience, but recognizing that there are a whole set of other considerations that could preclude somebody from physical presence in Canada at all times. But I will cite, by way of just one example, the Lebanon-Israeli crisis in, was it 2006 or 2007, where some 15,000 Canadians were airlifted from Lebanon, brought to Canada, stayed in Canada for a very short period of time, having not lived here for many, many years, before returning back to Lebanon. And when we're confronted with that kind of reality, we have to ask ourselves an important question about how does an individual Canadian enrich the Canadian experience? And typically it's done by participating in and being part of the fabric of Canadian society over here. So I don't know that there's such a black and white solution. I simply think that it's important to integrate the intent to reside, mindful of the citizenship of convenience challenge that I think that we're faced with as a country.
Okay, thank you. You have supported the revocation provisions of Bill C-24. How can you justify supporting a provision that seems to target particular minority groups and has been shown to generate suspicion and mistrust of many minority groups by the broader population?
Yeah, so I'm not insensitive to that particular challenge and the exchange that you had with Professor Winter. I recognize that that too is a difficult issue. I also recognize the mandate of the current government and its expressed intent with respect to this issue. For us, it's almost a philosophical problem, and if I can, by way of analogy, just talk about a marriage. One goes into a marriage, into that kind of partnership, with an expression of a commitment to a set of values. If those values are breached, then the solution that more often than not occurs is a divorce, because the individual's through the individual's actions, they've repudiated the essential values that caused them to go into that union. So for us, for a particular set of crimes, and we listed what we thought that they were, we felt that somebody has not just been guilty of the objective crime, but also a crime against Canada.
Mr. Fogel, your time unfortunately is up. Thank you. Mr. Soroya, 7 minutes, please.
Thank you, Mr. Chair. Mr. Chair, I'll be splitting my time with Michelle here. Thank you for the panel. We hear from both sides. My question is for Mr. Fogel. It seems, differ from Mr. Edelman. In your opinion, you're suggesting those people who are committing heinous crime against the country or the Canadian citizens, innocent people, among the other people who commit crimes in the other countries, they should be deported back to save Canadians, save whatever the thing. Can you elaborate more on it?
So I listened very carefully to what Mr. Edelman said, and I'm actually not sanguine nor insensitive to the points that he raises. I don't propose that these are easy issues with easy solutions. I'm also mindful and had not frankly fully considered something Professor Winter said about what the consequences of deportation can be, not just for the individual, but for the environment or the locale in which they go to. Which is why I think that I acknowledged in my comments that the government's position offers some compelling arguments in its favor, including, as Mr. Edelman said, not differentiating between different Canadians, those who were born here or those who were naturalized as Canadians. But I still can't escape the fundamental philosophical problem that I have. When we talk about a convert to a particular religion, as opposed to somebody who was born into that faith, they're making an active choice. They're making a declaration that for whatever reasons, that faith resonates with them. It's something that they want to embrace. When they do something to so fundamentally offend the values of that particular faith community, or in our case, the values of Canada as a society and a country, then there has to be some kind of response. There has to be some kind of consequence. It may not be revocation. There may be other remedies that could be contemplated. But surely the insult to Canada requires some kind of recognition and redress.
My second question is for Professor Winter. Can you tell us about the impact of language skills on successful integration in the case of Canada, especially knowledge of English and French?
Oh, I think that research has clearly shown that language is important. I mean, language is always both. That is the, you know, I don't have to tell this to Canadians, that language is both. It is a means of civic and economic integration. It's also a means of cultural integration. I mean, we've lived close to Quebec, so we know this. And in that sense, I think it is an important fact. However, I would also just think that testing language is in itself it doesn't do it all. I mean, in order to just be here, or, you know, the residence time, and the meaning that someone can be here and learn the language is in itself, it can only be a proxy, whereas language requirement or skills need to be involvement with other people. So that's.
Thank you. Ms. Rimpel.
Thank you. If we have time, I'd like to go back to that, but just I guess both for Mr. Fogel as well as Mr. Edelman, we've had witnesses come before committee on this bill to talk about the perhaps going farther than what's in the bill in terms of the revocation of citizenship, particularly in terms of being able to revoke citizenship based on citizenship being obtained by fraudulent methods. I'm just wondering, Mr. Fogel, if you think that this is necessary, and if so, what you would suggest in terms of an amendment, or if you don't think it's necessarily, especially in light of the Overlander case. And then, Mr. Edelman, I'm just curious, based on what you said, how we can safeguard the perception that if you do present fraudulent information and somehow you slip through the cracks of our review system, which sometimes happens, that's why this, you know, provision exists, how we can sort of safeguard the obtainment of Canadian citizenship from someone who would be trying to achieve Canadian citizenship through fraudulent means.
So I think the case for action against those who willfully commit fraud in the application process is a more straightforward and easier case to make. I think that the ability to consolidate the process in terms of appeals that can be presented by the defendant would be helpful in ensuring that justice is done in a timely kind of way. But I do think that there is indeed not just value, but a legal and moral imperative to maintain those kind of provisions, which I think in every respect are different than the debate about revocation after the fact. So, you know, somebody who is intending to misrepresent or to commit fraud can't benefit from the results of that fraud having been perpetrated.
And I think, and I don't disagree with the proposition that there is revocation based on misrepresentation. It's built into the Treaty on Statelessness as well. What my suggestion is, and perhaps the example of permanent residence is a good one, is that we revoke many, many more permanent, or we remove the status from many, many more permanent residents than we do citizens historically. And the process is relatively straightforward. There's an allegation made by the minister. You go to the immigration division. If the immigration division finds you misrepresented, there's an order issued, and you get a chance to go to the immigration appeal division. But not all misrepresentations are the same. So if, let's say, 25 years ago, you came here as an engineer, and your engineering diploma was not, in fact, genuine, and you were more of a technical trade, 25 years, you've had children, grandchildren, whatever, that you're established here. There may be reasons why you don't take away someone's permanent residence in those circumstances today.
Thank you, Mr. Edelman. Thank you. Your time is up. Ms. Kwan, 7 minutes, please.
Thank you very much to all the witnesses and for your presentation. Just to carry through on the question around revocation and on the issue around misrepresentation or fraud, is it my understanding, Mr. Edelman, then that the issue here is to ensure that there is a process for each case to be considered, and that is not to say that if someone misrepresented, they should automatically have their citizenship revoked or not revoked. It's simply to ensure that there is due process in place and a fair process in place. Am I assuming correctly that is your request of the committee to consider?
That's correct. So my position is not that there shouldn't be revocation in these circumstances, but that there should be a more rigorous process, and that people shouldn't be put in a more precarious situation when they become citizens. Because the example that I gave of the engineer from 25, the misrepresentation from 25 years ago, when they show up in my office and say to me, should I become a citizen? They know they've misrepresented, and there's not much they can do about it. My advice to them is, don't become a citizen, because your situation will become more precarious once you become a citizen. Because once you're a citizen, if an officer decides you've misrepresented, you go all the way back to being a foreign national and an inadmissible foreign national, and can be removed with no process.
Okay, thank you. And so on the same vein, actually, I think the argument, might this not then also apply for those with a criminal record abroad? Because as it stands right now, Bill C-6 did not make any changes relative to Bill C-24, and that is to say that if you have a criminal record abroad, indictable offense, that you're automatically exempt for consideration. You will not become a citizen here in Canada. So that we have seen situations like Mr. Fami's situation, right, where in other jurisdictions their judicial system might be different. There might be other factors that should be considered. So I wonder whether or not on that issue, what your thoughts are, and should there also be a proper process to deal with that as opposed to an automatic decision?
Well, and I think that's a different stage in the process. What we're talking about at that point is the acquisition or the grant of citizenship and the bars to the grant of citizenship. And in my view, the problem with that is that there already is a mechanism in the Act for dealing with that. So a permanent resident who's committed a serious crime or who's been convicted of a serious crime overseas can lose their permanent resident status and are then not eligible to become a citizen. The problem with building it into the Citizenship Act as an on-off switch is that there's no room for context. There's no room for looking at whether or not this is in fact a serious crime and whether or not the person should be barred from citizenship. What it says is if you've been convicted of these types of offenses overseas, you are not eligible for citizenship. The way it should, in my view, the appropriate process is if it's serious enough, take away the person's permanent residence. If it's not serious enough for them to keep their permanent residence, then let them get on with integrating into Canadian society and becoming a citizen. So that, in my view, there's already enough mechanisms in IRPA to deal with that, and adding it into the Citizenship Act creates problems rather than solving anything.
Thank you. So then I guess what you're calling for is for that provision to be amended or revoked from the bill itself.
That would be my recommendation.
Can I just touch on the issue around language? It's been presented to this committee around the issue on double testing, and particularly with immigrants whose language capacity, where they have to do the test on the knowledge of Canada, either in French or English, and that's deemed to be double testing. And I wonder what your thoughts are about that.
Well, I think that the double testing issue is the fact that you do a language test to be able to become a citizen. So you need to meet a CLB4, I believe it's a CLB4 benchmark. The problem with the knowledge test is that by making the knowledge test, testing knowledge and testing language are two separate criteria that have been set out by Parliament. And we can debate about the scope of those and whatnot. But if you're going to have a knowledge test, the knowledge test should be separate from the language test. You're testing knowledge, and what's happening right now is that the knowledge test, by virtue of having to be done in English or French, becomes a second language test, and arguably is a language test that might be hard for someone who could otherwise pass a CLB4. So they're having problems passing the knowledge test because of the language, not because of the knowledge. And so test the knowledge separately from the language would be my recommendation.
And what was the system before Bill C-24?
You could do the knowledge test with the assistance of an interpreter. So you would be testing knowledge separately from language. So you test the knowledge of Canada, but you do it through an interpreter. And so you might know Canada, you might know the history of Canada inside out, but if you can't do it in English, you're not going to pass the test, even though you might be one of the, very knowledgeable about Canadian history.
Thank you. I'm just going to touch on the issue around humanitarian and compassionate considerations. You touched on that in your presentation. Can you tell me about the importance of why that should be considered in the case of when someone's application for citizenship is being revoked?
Well, in some circumstances, what you're dealing with, one, is that there's no statute of limitation on misrepresentations. So you're talking about misrepresentations, and the example that Mr. Fogel gave is of a misrepresentation in 1954. Now, a very, very serious misrepresentation. There's no doubt that in those circumstances, it may well be appropriate to go after somebody who misrepresented, however many years, that's 60 years ago. But in other cases, if somebody, you take the example of the engineer that I gave you earlier, if they misrepresented 60 years ago and have since become an engineer and have established themselves here, and there may be factors that make taking their citizenship away unfair, even though technically they did misrepresent. But there's a big difference between the scope of the misrepresentations that we're talking about and the context within which somebody's status, how long they've been here and their establishment here. So I would say that those factors are relevant and should be considered.
Thank you, Mr. Edelman. Mr. Chen, 7 minutes, please.
Thank you, Mr. Chair. My question first is for Mr. Fogel. You cited historical examples to demonstrate your support for citizenship revocation. And as you know, under Bill C-6, citizenship can still be revoked for reasons of fraud or misrepresentation. You seem to be satisfied that these grounds should remain for those that willfully, as you put it, commit fraud. How do you determine, however, what is willful fraud? Some critics have argued that under the current legislation, a single immigration officer is empowered with making that decision of whether or not to revoke citizenship on these grounds. It seems to me that it's quite a subjective decision. What are your thoughts on this?
So I wouldn't disagree, and I think that there's a compelling case to be made for putting into place the kind of protocols that would ensure that while there's sufficient flexibility to distinguish between, with some nuance, different kinds of misrepresentation and context and so forth, that we should also put into place safeguards from the kind of arbitrary decisions that could be made by single individuals who are evaluating cases. So I think that there's room for putting into place the kind of mechanisms that would ensure that the individual has the protections of law without undermining the core principles that inform the whole Citizenship Act.
So would you support then a full hearing, and if someone were to lose their citizenship, a right to appeal for those cases where citizenship has been revoked for fraud or misrepresentation?
So the chairman will be very pleased with this response because it's brief. Yes.
Good. Currently, there are two organizations that have launched a lawsuit, and they argue that the current process for citizenship revocation under Bill C-24 not only is problematic for the stated grounds of that are related to national security, but they argue that charter rights are violated. They believe that these elements of the current law are out of line with a free and democratic society, and I wonder, what is your opinion of their claims?
So I'm just not sufficiently familiar with the arguments that they're advancing to offer a comment. I'm sorry.
Okay, I would throw the question out to the other witnesses.
I'm not aware of that case either, so I can't speak to it.
Yeah, in terms of the positions taken by the other organizations, I'm not sure what the positions are that you're suggesting.
Okay. Well, their position is essentially that the current process of citizenship revocation, which is what we've been discussing, and specifically also around the revocation of citizenship based on grounds of national security, those they contend are violating the rights of the charter rights of individuals.
And I can say that there are several lawsuits that have been, and our office is involved in at least one case with respect to challenging the current provisions, is that taking away citizenship without a hearing is a problem. It's a problem of procedural fairness. It's a problem with respect to taking away a right as fundamental as citizenship. Citizenship is a right. The rights of citizenship are integrated into the Charter itself in terms of fundamental rights to vote, mobility, moving in and out. It's a very fundamental status to take away with no hearing.
Yes, I've heard about the same claims. I'm not a lawyer, so I let my legal colleagues speak on that. However, again, it is what is the alternative? Taking away citizenship. What about the other country then? Should they too? Where does it lead? Seems to be a kind of a race towards taking away and not being, able to having to pay for that individual. It really means to say to someone, you have no country, and that in the world of nation states is, as we know, pretty harsh sentence.
Okay. I want to follow up on Mr. Edelman, your comments around the language vis-a-vis knowledge test. Some would argue that it's very important for someone who is making Canada their new home and making that choice to become a Canadian citizen, that they have a certain level of knowledge about the country, and you've talked about the problem with having a knowledge test that is in English or French, because some people might find that difficult to pass, not because they don't have the knowledge about the country, but because they don't have a sufficient level of proficiency, one which may exceed the requirements of the actual language test. What is your solution, if you have one to propose, around ensuring that new Canadians do have a sufficient basic knowledge of the country?
Sorry, just to be clear, my criticism is not around the knowledge test itself. My criticism is around the knowledge test being done in English or French. And to give you an example from my own schooling, I did school in French. I learned my math and science in French. It took me years before I could even say Pythagorean theorem in English, because it's a very difficult thing to say. But it's actually very difficult for me even now. I've learned over the years, but science and math don't make as much sense to me in English as they do in French. because but it's not that I don't understand the concepts, although my grasp of the concepts is not particularly at a high level, but I understand the basic concepts, but I understand them better in French than I do in English because I learned them in French. So it's more about doing the knowledge test. You might have the knowledge of Canadian history and understand the democratic principles and the democratic rights and all of those kinds of things, but the language that's used to describe those things is often at higher than a CLB4.
Thank you, Mr. Edelman. That concludes our round of questioning, and I'd like to put a quick question to the three witnesses. One of the fundamental principles of our justice system is that every citizen is treated equally before the law. The question is quite simple. It can be answered yes or no. Do you subscribe to this principle? Mr. Fogel?
So for me, it really reflects competing imperatives. I recognize the force of that argument. It's the position that the government has staked out. I still think that there are circumstances in which the breach is so fundamental that it requires some other remedy that we have to put into place.
Thank you. Ms. Winter?
I subscribe to that principle, and I think that citizenship revocation targeting dual nationals, because it's the only ones who can be targeted by it, does not treat them equally. Although I do understand that philosophical kind of dilemma.
Thank you. Mr. Edelman?
And yes, I would say that yes, they should be treated equally before the law. And just to come back to one of Mr. Fogel's example that he gave of a marriage, I would say that a more apt example is one of having a child, is that renouncing a child is something that is very, very rare. Marriages break down a lot. Unfortunately, it's the reality of...
Mr. Chairman, he opened the door. Can I just take 30 seconds to respond? The difference between that is that the child is a product of the relationship. In the case that we're talking about, it's the individual who is taking upon her or himself independent actions that are an affront to the partnership that they entered into.
May I
yes.
Since you opened the door to speak to a sociologist, then we would also say that individuals do not only act on their own. I mean, I'm not condoning acts of violence, acts of terrorists, but we have to take into consideration context, and I think in that case, we all may be guilty.
Thank you, Professor Winter. At this point...
Point of order, Mr. Chairman. You have done this before. You've just very conveniently taken the conservative time to ask questions. You have the right to ask questions, but not at the prejudice of members of the committee. Your job is to make rulings. You can ask questions from time to time, but almost every meeting you have done this, and I ask that you stop.
To your point, the chair may on occasion participate in the questioning of witnesses, and that's in O'Brien and Bosch on page 1067.
I'm well aware of that, but this is not on occasion. You're doing it at every meeting. So I just want to make a point. I resent your using up the conservative time.
The round of questioning had concluded. It's not using up anyone's time. Thank you.
We'll have this out again, Mr. Chairman, if you do it again, and I'll take longer.
Okay. Thank you. I'd like to suspend for 2-3 minutes to allow the witnesses on this panel to depart and the next group of witnesses to settle in. Thank you. The meeting resumes. I'd like to welcome our second panel today, which consists of Mr. Richard Kurland, lawyer and policy analyst, here as an individual, A.V. Go, clinic director, and Vincent Wong, staff lawyer of the Metro Toronto Chinese and Southeast Asian Legal Clinic, Mr. Stephen Green, lawyer partner, Green and Spiegel LLP, also here as an individual. Thank you. And Mr. Green, you start off with 7 minutes, please.
Great. Thank you very much for inviting me here today. What I would like to discuss today is a very specific provision within the bill, and that's dealing with residents. I certainly commend the government with respect to this bill in reducing the amount of time down from 3 years within 5. However, I would also ask you to look at the requirement of physical presence. For the past 30 years or so, physical presence has not been the test in Canada, and we've provided applicants with the ability to apply for citizenship when they haven't lived here physically based on certain types of circumstances. But with the introduction of the new act back in June of last year, I think it hurt a lot of people that as Canadians we don't want to really hurt. I propose to you, should a journalist from CBC who is posted abroad have to decide between becoming a citizen or taking that posting? Should a permanent resident that's been accepted to MIT, to Harvard, that could get a wonderful education, bring that back to Canada and help us, have to choose between taking that education or becoming a citizen? But one that I think will hit home to a lot of you is this question. Members of this House are no less residents, I submit, because they're here in Ottawa. Think of the time that you spend here in Ottawa, but where is your centralized mode of living? I would suggest back in your home ridings. Why? Because you have a home, you may have a family, you have social connections, bank accounts. And what is happening is that you can ask the question, because that Member of Parliament spends time in Ottawa, are they any less a resident of Manitoba? Are they any less a resident of Quebec? So I suggest to you that the current bill is asking you to do that, and I don't think you want to. So we need exceptions to that physical presence. And as many of you may know, prior to June of last year, we basically had 3 tests inside of Canada to determine whether you met the old residency requirements. There was one which is a purely physical test. There was other 2 which are referred to, one as the Papagirgakis case, which is a story of a gentleman that was a student in Nova Scotia that lived in a bus in Massachusetts, went to school, and the court there said that if you centralized your ordinary mode of living in Canada, then we would count that residence time. And then the last test, which is called the coup test, was a test where Madam Justice Reed had set out 6 questions, some of them being, do you spend more time outside of Canada than inside? Was it a voluntary reason you went abroad? Did you return home after you were abroad? So those 3 tests were used and available. But the problem was that the courts have held that as long as a citizenship judge chooses one of the 3, then that judge has not made a mistake. So, quite candidly, it was like going to a casino, where whatever judge you got, you knew, yes, you were going to get your citizenship, or you weren't. So we have to have a system that will get rid of that lack of transparency, but one that will go ahead and at least provide the opportunity for students and workers to go abroad. And this is common in other countries, and I give you just 2 examples, one being the United States of America. In the United States, we're told that you must be a resident of Canada, physical resident, for 30 months within 5. We reduce it, it's interesting, if you're married to an American citizen, and that is a period of 3 years where you must show that you've resided for 18 months. But then they go on to exceptions. What are some of these exceptions in America? Well, if you work for an American company abroad, you can count that time towards your physical requirement. Do you work for a media organization? Do you work for a religious organization? So in the United States, they have exceptions, and we must look at them. In the United Kingdom, same type of test where they go ahead and they say you must be a resident for 3 out of 5 years in the United Kingdom. But again, they give exceptions. What are some of these exceptions? Ask the applicant where their family is, where is their main business, where are their social connections. So you see, the UK and the United States provides this exception, and I submit that we should. So what do I recommend? I recommend that with respect to the current bill, if we keep the physical requirement in, we go ahead and we provide exceptions. Some of these exceptions I would submit to you is working abroad for a Canadian company. 2, studying as a full-time student abroad. 3, perhaps that you are working as a missionary abroad. So we have to look at some of the exceptions, because I think at the end of the day, we as Canadians are going to lose some great people that should be part of our Canadian community. And you can even look at our Immigration and Refugee Protection Act. Section 28 of that act talks about who can renew their permanent residence. One of the exceptions about physical presence in 2 out of the 5 years is you're working for a Canadian company on a temporary basis abroad. So again, we've recognized that for permanent residents. I believe that we should recognize it for our citizenships. And finally, if this committee decides not to look at the recommendation of removing physical presence, then yes, we have section 5.4, which is a provision that says that if the person doesn't necessarily meet the residence, then the minister can look at various reasons. But the problem with that is that it's not transparent enough for us. We must have transparency in such an important type of thing that we provide to our people. Thank you.
Thank you, Mr. Green. We now move to Ms. Goh and Mr. Wong, a combined 7 minutes. Thank you.
Thank you. My name is Avi Goh. I'm the clinic director of the Metro Toronto Chinese and Southeast Asian Legal Clinic, which is a not-for-profit community-based organization providing free legal services to low-income people in the Greater Toronto area. With me is Vince Wong, who is a staff lawyer at our clinic. And we're very pleased to be here, and we thank you for the opportunity to comment on the bill itself. For us, Citizenship Act is one of the most important pieces of legislation in our country. Citizenship defines who we are as a people, and therefore what Canada is as a nation. Being able to become a Canadian citizen is important, particularly for many immigrants, because our legal system reserves certain benefits and rights and privileges to those with citizenship status, and of course the most important of which is the right to vote. Citizenship also gives immigrants to Canada a sense of belonging and reaffirms their place in the country that they call home. And it's important for many of our clients at the clinic, many of them are racialized, many are non-citizens. For them, they need to be reassured that our Citizenship Act does not promote injustice and exclusion. In fact, I will argue it's in the interest of all of us, of our country, that our citizenship law signals to all of our immigrants that the Canadian society is a welcoming place for all people, regardless of their race, gender, socioeconomic status, and so on. So we are pleased to see that Bill C-6 repeals many of the provisions that the previous Bill C-24 has put in. For example, resetting the language and knowledge requirement so that they only apply to applicants aged 18 to 54, repealing the intent to reside provision, and reinstating a half-day credit for time spent prior to acquiring permanent resident status. These and other more are positive changes, but there still exist many serious problems with the current framework, and I'm going to turn over to my colleague to address some of those problems.
Thank you. I'll dive straight into the issues. Firstly, it's our position, and we support Mr. Green's eloquent arguments on this, that an overly rigid application of the physical residency test would leave otherwise deserving applicants unfairly barred from citizenship. And we see these cases all of the time, from clients who spend time abroad for business or schooling, but what I would outline is also for those situations of compassionate care. For example, cases where clients go back home to take care of their ailing parents. And therefore, we recommend that, whatever test the committee deems appropriate in this situation, whether it be the coup test or the centralized mode of existence, really gets at the heart of providing that flexibility in situations where it's deemed just. And we believe that putting in a deemed residency test that focuses an analysis on a centralized mode of existence would get to the heart also of the concerns surrounding citizens of convenience, so-called. And we also submit that putting a deemed residency test will balance the interests of legal clarity and processing efficiency on one hand with concerns of fairness and equity on the other hand. The second issue that I'd like to get into is that we recommend the right of appeal to be reinstated for all citizenship decisions. Previously, the Citizenship Act allowed for an automatic right of appeal to federal court for essentially all citizenship decisions. Bill C-24 replaced this automatic right of appeal with a far more limited judicial review, only with the permission or leave from the court. We submit that it is of critical importance for the rule of law that there be proper judicial scrutiny of all citizenship decisions to ensure that they are, one, legally sound, and two, that discretion is being exercised in a reasonable fashion. This is only possible when effective avenues exist to challenge these decisions. Finally, my third point relates to that of the policy of requiring an upfront language test to prove language skill for citizenship. And we recommend that this policy be completely scrapped. The reason is the policy is a double whammy for immigrants because that it erects, one, a language barrier, but also, two, a financial barrier to citizenship, in that applicants would actually have to pay for testing as an a priori matter before the application is even processed by CIC. We recommend that it be placed with the pre-Bill C-24 system, which allows decision makers to determine whether there is sufficient knowledge of language through an oral hearing or interview. We also recommend that the requirement of a written knowledge test be taken in French or English be repealed, as this requirement essentially amounts to a second language test that we heard a little bit earlier. And we agree with the CBA submission on this that, quote, language competency that's required to pass a knowledge test is significantly different from the language requirement required to live and work practically in Canada. Previously, language requirements have always focused on practical listening and speaking skills. Requiring applicants to pass a written test in English or French creates additional reading comprehension and written language requirements, areas that had historically, prior to Bill C-24, not been deemed necessary for naturalization. Now, I appreciate that there are members of the public who, out of good intention, want to promote acquisition of English and French among immigrants in order so that they can better improve their socioeconomic outcomes. And we agree that language acquisition is an important goal for successful settlement. However, this is a situation where you've already got the carrot, you don't need the stick. And when you use the stick,
Mr. Wong,
unintended consequences may happen. Many immigrants and refugees arrive at the bottom of the socioeconomic ladder. They don't have time when they're working multiple jobs and taking care of family to get formal language testing done.
Thank you, Mr. Wong. Mr. Curlin, 7 minutes, please.
2 points. The proposed amendment to Section 5 of the Act has a Titanic-sized loophole. The second point is the strategic design flaw in the proposed bill. So first, before I begin, express deep pleasure at the honor and privilege at again being before this standing committee. Thank you for having me here. The goal of including references to Income Tax Act filings was to resolve the irony that one could be a resident in Canada for immigration purposes, but not for tax purposes. If you're going to live here and obtain our Canadian benefits systemically, pay for them. Pleased to see that component of the current law survived the electoral transition. But There's a gaping loophole. The proposed amendment in its current form fails to include 4 tiny words. I'll read the sentence. The relevant part is that meet any applicable requirement under the Income Tax Act to file a return of income in respect of 3 taxation years as resident of Canada. Otherwise, a person can file an income tax return as a non-resident, thus defeating the core intent of Parliament that if you wish to be a citizen, you must be resident in Canada not just for immigration purposes, but taxation purposes. The second point relates to our citizenship revocation process. Simply put, in its present form, there are less procedural safeguards for citizens than permanent residents enjoy. It needs a rethink. Structurally, it's possible to engage a new division at the Immigration, Refugee, and Citizenship Board, possibly, that can structurally channel citizenship issues for adjudication in a quasi-judicial forum. The alternative structurally is to substantively downgrade the person concerned from citizenship to permanent residence in order that they can attain access to a modicum of justice. Those are the 2 points. I owed the chair 2 minutes from last year for going overtime. I restore what I owed.
I know that it's highly appreciated by the previous chair. Mr. Asasi, 7 minutes, please. Thank you.
Thank you, Mr. Chair. I wanted to thank all the witnesses. I've had the opportunity to go over all your statements, and it's quite obvious that each of you obviously bring a lot of expertise to bear, and you've taken the chance to actually go through the legislation, through the various provisions to ensure that we do have a good Bill C6 to ensure that there are no shortcomings, gaps, and things of that nature. But I was wondering if I could ask each and every single one of you whether you agree that insofar as the revocation provision is concerned, there aren't enough procedural there isn't enough procedural oversight or mechanisms, if you agree with that particular statement, and what you would envision to ensure that we can strengthen that particular area of Bill C6. And I'd like to ask all 3 of you to answer that question.
Perhaps I'll go first. Under the current revocation system, I do not think there's enough safeguards. You should be aware that there's a very large class action suit right now dealing with the changes that occurred last year. And I think that we need to have proper court oversight in the process. You also, it's interesting, we have an immigration appeal board that sits, that deals with refugees, that deals with adjudication matters under the Immigration and Refugee Protection Act. You have a board right there to perhaps be the oversight dealing with citizenship. So you may want to consider that board looking at that. And just one very quick comment with respect to revocation. One of the cases in the court is of a situation where it was a family of 4. There's an allegation that the main applicant had misrepresented something on his citizenship, on his immigration, and they were going after all the children as well. And that is the problem. With this situation, there's not enough oversight. It's just an officer looking at it, making the decision. So I would say we have to have proper oversight, and there isn't under the current system.
I absolutely agree with that assessment. And it's kind of ironic that we have more right to appeal from a parking ticket than having your citizenship revoked. And I think a lot of good suggestions have been made, whether you expand the IRB jurisdiction to include citizenship cases. There are questions about the agency factor, the humanitarian compassionate factors, that could also be included upfront when an officer decided whether or not to refer a case to a hearing. And of course, we need judicial oversight at the end of the day, whether you're sort of like a right to appeal to federal court or judicial review from a decision from a panel such as the Immigration Refugee Board. I think all of those are very good suggestions.
My goodness. The role of the witness is to assist in improving a proposed bill. It's passed in principle. Clearly, we're in a transition of philosophy from making citizenship harder to get, easier to take away, to a place where citizenship is easier to get and harder to take away. Yes, in that context, revocation needs an overhaul. Fundamentally, our criminal justice system in Canada is there to sanction inappropriate behavior with penal consequences. That is not the function of a Citizenship Act.
And just to add, I think just as a matter of principle, you're always thinking what is going to be the consequence or the significance of the consequence of the rights that you're taking away. And if those consequences are really material, which I would argue in the case of citizenship as a meta right, it is really fundamental to any individual who is subject to revocation, that if that is very significant, then your procedural safeguards have got to be very high. And if it's not significant or very somewhat immaterial, then you have more leeway. But certainly, I agree with the notion that if we're talking about fraud and misrepresentation, the IRB does these cases all the time for permanent residency. So you might want to look at leveraging the expertise that they already have in these sort of issues for the purposes of citizenship.
Thank you. And then given the time limitation, I just wanted to ask Ms. Go and Mr. Wong about Section C of their submission, which relates to the issue of expansion of bars to citizenship for foreign charges and convictions. In that particular section, I thought you made a very compelling argument in which you were talking about how there is this inclination for many to conflate immigration law with criminal law, and how that is fundamentally flawed because the systems each are supposed to act independently. So if you could speak to that particular issue, I'd be very grateful as well.
Sure. So in addition to the concern about conflating immigration law with citizenship law, we are also concerned about the fact that while in Canada we are governed by rule of law, we have a constitution, we have charter, that's not always the case with many other countries. At our clinic, we have mostly clients from China, Vietnam, and I think a strong argument can be made that rule of law is not always present in those systems. So it's very problematic that we start to kind of equate foreign convictions with convictions in Canada, for instance, and also to use the citizenship process to basically doubly penalize someone who may or may not have been wrongfully convicted overseas. So I think for those reasons, we are very concerned about this.
Right, and I just quickly add to my colleagues' submissions that it's a seductive notion, right? They're criminals, they're bad people, we want to punish them.
10 seconds, Mr. Wong.
All sorts of avenues to punish them, but it's a slippery slope because we have a good criminal justice system here. It has procedural safeguards. So when you put the criminal punishment on top of the immigration or citizenship punishment, you violate a lot of those procedural
Thank you, Mr. Wong.
safeguards.
Mr. Tilson, 7 minutes, please.
Thank you, Mr. Chairman. I'd like to ask a question to Mr. Green and Mr. Curlin in particular, and that has to do with the Clause 1.8 of C6, which repeals the requirement that a person intend to reside in Canada if granted citizenship, and this was established in C-24. And I guess my question is, are you concerned that Canadian citizenship might be sought by those looking for a citizenship of convenience without the intent of living in Canada once it's obtained? It appears that there are many citizens that get their citizenship and then they're gone. They go to Saudi Arabia and make a lot more money there. I don't mean to pick on Saudi Arabia, but they go to another jurisdiction where they make substantially more funds than they do here. And one of the witnesses in the first round gave the example of Lebanon. In July of 2006, there were 34 ship evacuations of Canadian citizens that left Lebanon. That's ships, that's not individuals. 34 ship evacuations and 65 air evacuations. And it's interesting to know that many of the people that had the air evacuations, even though it was paid for by the Canadian government, they wanted the travel points. And that amounts to approximately 15,000 Canadians at a cost of about $75 million. Many of those people returned to Lebanon when things settled down. That's just one example. And so that section is gone. So I think it was raised perhaps by Mr. Wong, I'm not sure, about this whole issue of citizenship by convenience. It's a great thing to have a Canadian passport. Many countries many people on this planet would love to have a Canadian passport. So those are my questions, Mr. Green, and then Mr. Curlin.
Thank you. I am glad to see that the intent section is taken out. First of all, from a practical standpoint, I don't think we could ever manage it. If a person becomes a Canadian citizen and they live, they leave after 1 month, is that okay? Or do they leave after 6 months? I don't think it's a practical section. And I say that if you meet the requirements that the government has put forward with respect to your residency, you become Canadianized. That's what we want. Are you a Canadian? Have you thrown your lots in with Canadians? And I think that's the purpose of the citizenship test. And with a global world, people moving, people working, I just think it was an inappropriate section to put in. And with respect to the Lebanon issue that's brought up, I don't think that has anything to do with intention. Those were Canadian citizens that were abroad. We decided to go ahead and help them. I don't think if that intention section was in place, it would have changed that one bit. So I'm glad to see that it's removed.
Mr. Chairman, just on that, the difficulty is many people who get these things, and I don't have the statistics with me, but once they get that blue passport, they're gone. Mr. Curlin.
Let's talk about money. If Canadian passport holder is not in Canada 10 years, 20 years, Canada's not spending money on that person. There's no draw. But the holder has an entitlement to emergency diplomatic services, insurance passport. First solution, it's a group insurance plan. Pay the premium if you're not in Canada for 5 consecutive years or failed to file Canadian income taxes as a Canadian resident during a certain period of time, and have a $1,000 to $5,000 passport fee for a non-resident Canadian. Problem solved. Similarly, the last solution is to adopt, and this will be very unpopular in the blue chip living rooms of this country, to adopt the American taxation rule where we tax based on citizenship and not residence. That's the second solution.
Thank you. Ms. Rumpel, 2 minutes.
A very brief question for all the witnesses, anyone who wants to jump in. I just want to be clear. Are some of the witnesses who have talked about criminal convictions being considered as part of a citizenship, are you suggesting that overseas criminal conviction should not be considered as part of a review of what eligibility for citizenship? A, and then if that's the case, my question is, oftentimes where we see revocation instances or we get rejections of citizenship, it's when somebody has just not put that on their application. So they've actually not disclosed that information. Can you kind of explain some of your comments in the context of that type of a situation and what you're suggesting? Because I think there's a lot of people who would say, well, if you want this to be considered on humanitarian grounds or whatever, why not just disclose it on the original application? So if you willfully not put that on your application, what about that situation? How do we deal with that?
I guess our concern is around because the foreign convictions themselves may not be, it may have been wrongfully obtained. There are too many variables, and it will actually make the citizenship applications process a lot more costly because it will require more resources to determine which conviction do you consider and which you don't. But if you do make that a requirement and require people to disclose, then I can see that, if someone did not disclose, then it becomes a, misrepresentation issue, right? But I think that overall, there are too many variables and too many questionable convictions for us to justify making it a requirement.
Thank you, Ms. Go. Ms. Kwan, 7 minutes, please.
Thank you very much to all the witnesses and for their presentation. I'd like to touch on the issue that was not discussed today, although it was in the submission from Mr. Wong and Ms. Go, and that is the issue around barriers to accessing citizenship. You touched on the issue around language, the upfront requirement, which your recommendation is that we should do away with that, and then the double testing as well. But there's also another issue around barrier to access to citizenship, and that's the financial barriers. I wonder if you can touch on that issue.
Sure. Basically, we've seen over the past few years over 500% increase in the citizenship processing fee. The justification, of course, is that it will put money into the system to cover processing costs. It's a money issue. But there are significant long-term problems with that, right? And the most obvious one is people with low income or people that are immigrants or former refugees. It's not that easy for a family to just cough up $2,000 in discretionary income to try to get a citizenship processing. So we're looking for either to reduce the fees altogether or to provide waivers in places where it's justifiable. But the other thing, and I'd like the committee to think on this, is that if you put these financial barriers in place, or language barriers or very other strict barriers to accessing citizenship, you're essentially disenfranchising a lot of people that are already marginalized, that might be in the situation where they can't get to that language level because they're working a lot or they don't have the money. But they're still here in Canada. They're still PRs. They still live here. They still work here. They still have children. They contribute to the community. The only difference is you're essentially disenfranchising them and exacerbating their current marginalization. And then we know that if they don't have a vote, the policies are not going to reflect any of their interests. So it's that sort of cycle that we're trying to break here.
Thank you very much. There's another issue that I'd like to ask about, and that is a group of individuals who are deemed to be stateless. And so for a whole variety of different reasons, they're in that situation. And I wonder whether or not you have any suggestions as to how or if amendments should be brought forward under C6 to address the group of individuals who are deemed to be stateless. I'll open it up for all the presenters.
I guess in our clinic, a lot of the stateless individuals are former citizens of Vietnam. So many of them have been in Canada for a long, long time, and some of them, for whatever reason, sometimes have lost their Canadian permanent resident status at some point. Many actually have mental health issues, and they, had some criminality linked to their mental health, lost their permanent resident, and become stateless because they have no country to return to. There are other situations as well, and I know that CCR, for instance, has raised a number of these concerns, as well as concerns around unaccompanied minors who are in Canada can't get citizenship without the parent. So I guess there is no one single solution, I think, to this issue. There are different situations, and some of them may not be dealt with in the citizenship law, but more under the immigration law. But certainly, I think that it needs to be addressed. But I don't think I can offer you one solution that will, address all the stateless issue, because there are different situations within which one becomes stateless. So.
Mr. Green?
Unfortunately, I really have not experienced it yet, so I really can't comment on it.
Mr. Kirtland?
Yes. It merits careful scrutiny for the following security reason. If I'm the HR director of a very nasty group in the Middle East seeking to do damage in Canada or in our like-minded allies, I would be focusing my recruitment efforts among the stateless who are physically present in Canada. They're ripe for recruitment. We must collect the empirical evidence, track this group carefully. We cannot leave them without remedy.
There are groups of people, for example, who are deemed stateless because they're second-generation Canadians. And so when they have children overseas, in that instance, they don't have access to Canadian citizenship. So in that instance, what are your thoughts about that? Should they be granted Canadian citizenship?
Yes, I think that's an area that needs to be improved. For instance, I have relatives who's the husband and wife. The husband was born in Canada, the wife wasn't. They're both citizens. And then I was advising them that when the kids were born overseas, make sure it's the father who applied for their citizenship, because if they apply for citizenship under the mother, then their children may not become a Canadian citizen. And then I think that example highlights the unfairness of the situation. So I think that certainly I would recommend that provision be amended.
Mr. Kirkland, quick answer on that, and I have one other question to ask if I have time.
The quick answer is merge the issue into the creation of a structural remedy for discretion in individual citizenship cases.
Thank you. In the case where minors are without a parent for a whole variety of reasons, they are precluded under Bill C-6 to make application for citizenship. And there are other witnesses who've come forward to say that we should have provisions to address that, along with people with disabilities, and to address that issue. So probably less than 30 seconds now, so splitting between all of you.
Agreed. They should be allowed to apply for citizenship.
There's a conflict between this proposed amendment and the rights of the child. International rights of the child.
So that is to say that they should have the right to make application, am I correct? I just want to be absolutely clear about that.
Thank you, Ms. Kwan. Mr. Chen, 7 minutes, please.
Thank you, Mr. Chair, and I'll be splitting my time with Mr. Tabera. I want to thank the witnesses for appearing before us today, and my question is directed to Ms. Goh and Mr. Wong. I want to first congratulate the work of the Metro Toronto Chinese and Southeast Asian Legal Clinic for their advocacy on immigration and other related issues. and I'm aware that the majority of your clients are of the Chinese descent. And I speak as a member of this committee, but also as a Chinese Canadian, to say that I know how two-tier citizenship doesn't work, and we know that the Chinese Canadians arrived in Canada in the late 19th century and were subject to the Chinese head tax, the Chinese Exclusion Act, and we're treated as second-class citizens. And I always say that we use history to learn from the mistakes of the past and to guide us moving forward. My question is related to what you believe can be done to better support marginalized groups that come to Canada. The Chinese were in Canada to help build the railroad, a job that Canadians at the time were not prepared to do. And as we all know, the House issued a formal apology 10 years ago, and the last spike, which was presented to the Prime Minister at the time, was lost and most recently found again, and this symbolizes how the Chinese were not given a pathway to citizenship and were not treated as equal citizens. We know that many people come to Canada as live-in caregivers, as temporary workers. Do you believe that Bill C-6 goes far enough to provide them with a pathway to become full citizens?
So with respect to temporary foreign workers and living caregivers, I think that the pathway to citizenship was blocked within the immigration law itself. So I think amendment needs to be made there in order for them to become permanent residents. Then they can apply for citizenship. With respect to support for the Chinese community, in the context of citizenship, I think I want to highlight 2 points. One is the need for a lot more investment in language class. And I agree, many of us would agree that it is better for immigrants to acquire the linguistic skills in order for them to succeed. But if you have low-wage jobs, if you have to care for your kids, this is not something you're able to do for a lot of time. And in fact, we're just about to release a report on Chinese restaurant workers on Monday that will show that a lot of them work extremely long hours without minimum wage and so on. So I think that support for immigrant settlement, language class is very important. But the second part, I think, is access to employment. Because one of the reasons why a lot of our clients actually have to leave Canada and go to other countries is because they can't get a job within their field in Canada because their international credential is not recognized in Canada. I remember one of my clients who used to work in IBM in China. She couldn't get a job with IBM in Canada. She had to move to the States to again work for IBM. So I think that those issues need to be addressed.
Thank you, Ms. Go. Mr. Tabar, 3.5 minutes.
Thank you all for being here today. My first question is for Ms. Go and Mr. Green. I've had some constituents of mine that have come here. Their families are Canadian citizens, but unfortunately one of the members has to travel overseas and is not. So could you give the committee examples of what you've encountered in otherwise desirable or worthy citizenship applicants would be unable to acquire citizenship as a result of C-24 restrictions and residence of physical presence requirements?
I guess 2 examples that we often see at the clinic. One is because of the access to employment issue. So the husband, usually it's the husband, who is not able to get a decent job in Canada. So the wife and kids are in Canada. The kids are going to school in Canada, but the husband often has to move, go overseas in order to get a job that pays enough to support the family in Canada. And of course, in some cases, they may not even be able to retain their permanent residence status because they may not be working for a Canadian employer. But at the end of the day, so the question becomes whether or not they have a centralized mode of residence in Canada. The second example would be kids, students who are studying in another country. Like I think somebody make an example of, sort of someone go to Harvard and Yale. It may not be Harvard and Yale, right? It could be other universities. But the fact is their families are here, the parents are here, the kids are going overseas to study, but they will come back to Canada. But then they will have to wait for much longer before they become citizen. Again, question is it really to our interest, best interest of Canada, to delay their citizenship application?
I don't think there's a person in Canada except a citizenship judge that's attended more citizenship hearings than myself with my clients. And I can tell you that the normal sort of situation with respect to the business people is that they've got successful businesses inside of Canada, they're exporting Canadian products, they're traveling abroad, and their family members, be it the spouse and the children, are eligible for citizenship, and they just can't get it under the new legislation. And again, they have to make the decision, do they limit their amount of business, which would be not a very good thing for Canada, or get their citizenship. So I think that's the typical one that I see, and I think it's a bad move. And years ago, it wasn't an issue before they, if they hadn't changed the law. These people would be able to demonstrate they've paid their taxes, their kids go to school, they've created jobs in Canada, and that doesn't matter anymore.
It's really putting their
30 seconds.
30 seconds. If I can ask this quickly to Mr. Green, you had a case of an immigrant from Cyprus. He was a student, I think by the name of Papadiogogracic. Can you tell us a little bit about his situation? Oh, no.
Can't tell that one.
No.
Thank
Okay.
you.
No problem. That's okay.
Thank you. That concludes this round of questioning. And I would like to thank all the witnesses for appearing before the committee. The committee will suspend for a couple of minutes to allow the witnesses to leave, and I understand there's a procedural matter that will be raised in camera. Thank you once again.